If your ex-partner tells you he has no money, and you know in your body, in the specific way you know things after 9 years of watching someone operate, that this is not true, I need you to understand something before you sit across from him in a mediation office and sign anything. Do not sign anything. I'm telling you this because of what happened when his accountant sat in a witness chair and was asked, under oath, to explain a discrepancy between two documents that should never have existed simultaneously. And I want to tell you what happened in that moment, what the accountant said, what the judge's face did, what it meant for my daughter and for me, but I cannot tell you that yet. First, I need to tell you where we were when the mediation started, because the before is what makes the after mean anything at all. My name is Sarah. I am 37 years old. I have a daughter named Poppy who is 8. We live in a 2-bedroom rented flat in Leicester that costs £890 a month, which is £240 more than it cost when we moved in 18 months ago, which is the kind of detail that tells you everything about the current relationship between income and housing. If you are raising a child alone on a part-time salary in a city that has decided rental affordability is someone else's problem. I work 24 hours a week as an administrator at a GP surgery. I earn £14,200 a year, after rent, utilities, food, and Poppy's school costs, the uniform, the trips, the reading books, the things that are technically optional, but are not optional in the way a child experiences them. I have approximately £140 a month for everything else. I tell you this not as a complaint, but as a financial reality that shaped every decision I made in the year that followed, because financial reality is not abstract. It is the thing you calculate while you are making breakfast and putting Poppy's shoes on and trying to seem ordinary when everything about the situation is the opposite of ordinary. His name is Mark. We were together for 9 years and separated when Poppy was 3. He is by profession a business consultant and by self-description a man of limited current means whose income had declined significantly following a restructuring of his client base. He had told me this during the separation. He had told the child maintenance service the same thing when I applied for a maintenance assessment. The assessment came back at £87 per month, based on his declared income of £22,000. £87. I want to be precise about what £87 means in the context of raising a child. It is approximately 2.5 weeks of food shopping, depending on whether anything breaks or needs replacing. It is not a contribution to housing or childcare, or the school trip Poppy mentioned 3 times before I told her we would have to see. £87 from a man who had run a consultancy business for 11 years, who owned a car I recognised as a current model, and who had, in the final 2 years of our relationship, spoken with confidence about financial decisions that did not reflect the circumstances of a person earning £22,000. Now, I want to stop and ask you something, because this is the moment where a lot of people, especially people who have been in controlling relationships, especially people who have spent years doubting their own perception of financial reality because the other person was always better at the language of money. A lot of people at this point decide they must be wrong, that the person they lived with for 9 years must be telling the truth because surely he wouldn't lie, to a court, to CAS, to the child maintenance service. Surely there is a reality they are simply not seeing. I want to name that feeling because it is a designed feeling. It is the residue of having lived with someone who was very good at making you doubt the thing you were looking directly at. And I want to say, if you recognise it, your perception is probably correct. The doubt is the mechanism, not the evidence. My solicitor was a woman named Frances. She was 49 years old and had the specific quality of someone who has spent her career in family law, and has decided that the most useful thing she can be is clear, not reassuring, clear. She looked at Mark's financial disclosure, the Form E he had submitted, declaring assets of £6,200, income of £22,000, and no beneficial interest in any property or business. And she said, "This does not feel complete." She said it without drama, as a statement of professional instinct. She applied for third-party disclosure. Third-party disclosure means that the court can require documents to be provided, not just by the parties, but by other entities, banks, businesses, accountants, where there is reason to believe relevant financial information has not been declared. Francis made a targeted application for disclosure from the accountancy firm that had handled Mark's business accounts for the previous 7 years. Mark's solicitor objected. The objection was overruled. The accountancy firm disclosed. The mediation office where we first met was a room in a converted terraced house in the centre of Leicester, furnished with the particular, deliberate neutrality of a space designed to make conflict feel manageable. Pale walls, a low table, chairs at equal height, a box of tissues that I chose to interpret as optimistic rather than ominous. The mediator was a woman named Janet. She had a calm that I found in that first session either reassuring or maddening, depending on which minute you caught me in. Mark sat across the table and described his financial position with the fluency of someone who has rehearsed. He looked tired. He looked, I noticed, with the specific attention of 9 years of watching him, like someone performing the version of himself he needed to perform, rather than being the version he actually was. The mediation did not resolve. We proceeded to court. Here is the midpoint. Here is where everything became significantly worse before it got better. In the week before the first hearing, Mark's solicitor filed an amended position statement. The statement introduced a new claim that during our relationship I had been the primary financial contributor in specific periods, and that any asset division should reflect this. It cited 3 years of bank records showing my salary contributions to our joint account and argued that the maintenance calculation should be reassessed in light of my earning capacity relative to my part-time hours. The statement suggested, in language I found both precise and nauseating, that my current part-time status was a lifestyle choice rather than a constraint imposed by the absence of childcare I could afford on my salary. A lifestyle choice. Poppy was 8 years old. She needed picking up from school at 3:15. I worked the hours around that pickup because the alternative was a childcare cost that would have exceeded my salary net of rent. Mark had not contributed to a childcare arrangement in 4 years, and he was now arguing that my reduced hours were a personal preference. I sat in Francis's office and read that position statement and felt something cold and very focused settle behind my eyes. Not anger exactly, something more useful than anger. I told Francis I wanted to proceed. She said, "I know. Let's talk about what we have." What we had. What the third-party disclosure from the accountancy firm had produced is the thing I have been withholding. Here is what it contained. Mark's consultancy business had, in the 2 years prior to his formal declaration of £22,000 annual income, invoiced clients totalling £187,000. The invoiced amounts had been processed through a business account in the company name. A portion, £43,000 over 18 months, had been transferred to a second business account that had not appeared in his Form E disclosure. The second account had been used to pay rent on a property in Nottingham. Mark did not live in Nottingham. The rent payments were £750 per month, made with regularity for the entire 18-month period. £750 a month to a property he did not occupy, while declaring income of £22,000. Francis made an application for further disclosure regarding the Nottingham property. The disclosure revealed that the property was occupied by a woman, whose name I will not use because she is not a party to this story, and the details of their arrangement are not the point. The point is the £43,000. The point is the second account. The point is that Mark had structured his financial life with sufficient care that the structure was only visible when an accountancy firm was legally required to show it. The hearing was a Thursday in March. The courtroom smelled of old carpet and the specific institutional warmth of a room that is slightly too warm for the number of people currently in it. Mark's accountant was called as a witness, by us, having been identified through the third-party disclosure. His name was Graham, he was 61, methodical, and had the expression of someone who has just understood, arriving in that room, that the documents he brought with him are going to be read more carefully than he anticipated. Francis asked Graham to explain the relationship between the two business accounts. Graham answered. Francis asked him to confirm which account had been included in Mark's Form E disclosure. Graham confirmed. Francis asked him to confirm which account had not. Graham confirmed. Francis asked him to explain the £43,000 in transfers. Graham said he had advised Mark that the transfers constituted a legitimate business expense. Francis asked him to describe the nature of the expense. Graham paused. He paused for 4 seconds. Then he said that the transfers had been recorded as client hospitality and premises costs. Francis asked whether a residential tenancy in Nottingham occupied by a private individual was accurately described as premises costs. Graham said that the categorisation had been advised by Mark and that he had not independently verified the nature of the property's use. Francis said, "So you recorded as a business expense an amount you had not verified was a business expense." Graham said he would need to review his files. The judge, a woman named Jennifer, said there was time for that. There was not. Jennifer found that Mark had made a non-disclosure of financial assets in breach of his obligations under the family procedure rules. She found that the £43,000 in transfers and the second business account constituted assets and income that should have been declared. She revised the maintenance calculation upward. The new figure was £312 per month, backdated 6 months. She also made a costs order against Mark for the third-party disclosure application. Partial win. Not the full picture. Not the full 187,000. Not an order for the assets held beyond the disclosed accounts. Because assets Francis could not fully trace, Jennifer could not fully order. The second account had been run through the company. The company's valuation remained disputed. There were further proceedings to come on the financial settlement of the business. £312 a month arrived in my account for the first time in April. Poppy does not know any of this. She knows we went to some meetings and that things have changed a bit. She knows that we can do the school trip now. She knows that on Saturday mornings I sometimes sit in the kitchen with a coffee and do not look anxious, which is a change she has not articulated, but which I can see she has noticed, in the particular way that children notice the things they do not have language for yet. The coffee is warm. The flat is the same flat. The rent has gone up again since the judgment. £920 now, which means the 312 is absorbed immediately into the gap that was always there. But it is 312 more than I had, and the gap is smaller, for now. The financial settlement on Mark's business is ongoing. Francis has made further disclosure applications. I do not know what those will produce. The second account, the Nottingham property, the client hospitality that was not client hospitality. These are all in the record now. Whether the record becomes a full accounting is a different question with a different timeline. Mark. I want to say something about Mark that I find genuinely difficult to say. He is not a simple person. In 9 years, I saw someone who was good at certain things, who loved Poppy in the specific limited way of someone who had not been taught that love requires sacrifice as well as feeling, and who had built a financial life that was, at its core, an expression of the same controlling need that had characterized our relationship from the inside. The hidden account, the undisclosed income, these were not purely about greed. They were about control, about maintaining a version of financial reality that he could manage and I could not access. I understand that. I'm not less angry about it, because I understand it. But I understand it. Here is what I want to leave you with, and I mean it for anyone who is sitting across a table from someone who is better at the language of money than you are. The Form E is a legal document. It carries an obligation of full and frank disclosure. It is not self-enforcing. It is not checked by default. It is only checked when someone asks the right question and has the resources to compel an answer. Third-party disclosure applications cost money and time, and the willingness to escalate. Most people do not have all three. I had Francis, and I had the specific stubbornness of someone who had spent 9 years being told that her perception of financial reality was wrong, and who had decided finally to find out whether she was right. She was right. What I want to ask you is this. If you had been in that mediation office, if you had sat across that table and heard £22,000 declared with a straight face, and felt in your body that the number was wrong, but you had no proof, and no money for legal fees, and a daughter waiting to be collected from school at 3:15, what would you have done? Would you have signed? Would you have found a way not to? Because I nearly signed. The first session, I nearly decided that £87 was what it was, and that fighting it would cost more than it returned. I want to know your answer. Put it in the comments, because the answer to that question is different for everyone, and every version of it deserves to be on the record.